Good evening, everybody. Thank you for coming to another SALT Talks. My name is Patty Schramm. I'm the Parent Resource Trainer and Coordinator for the SALT Talks series. So this whole month, we're looking at how to prepare for when I'm gone. I mean, I know a lot of us, um, me included, we always think, we have a long time to get things together, but we do have to plan and start preparing for that time. So the transition is a little smoother as best as it can be. But so we're looking at that this whole month. So tonight we're going to be talking about in someone else's shoes. It's about guardianship and the alternatives. How do we get ready for this? What do we need to know? Is guardianship right for me? Is it, do I have other options? Those are all questions that come up, especially as your child hits that adult age and starts is out of that considered childhood and into that 18 and older age. So tonight we have Brittany O'Dime. She's here with she's an attorney at law. She's hosted or spoken several times at our SALT programs on this very topic, and she does such a clear presentation every time. So we invited her back for this year. Usually I always hit Easter or something. So this year I tried to make sure, but I still hit St. Patrick's Day, I guess. But anyway, so I'm going to turn it over and I'm going to let you introduce yourself and tell a little bit more about yourself, Brittany, and you can go ahead and start with the presentation.
Great. Well, thank you, Patty, and thanks
Mhm.
as always for having me here. I love getting to do this. Love getting to help educate. Education is a really big passion of mine. So if you give me just a moment here, I'm going to share my screen and get the presentation pulled up. And I think Patty gave you guys access to the slides and such, so you should be able to hopefully have something that you can take notes on as we go through. But okay, here we go. So um, I'll start by way of introduction. So the excuse me, as Patty said, my name is Brittany O'Diam, and I am an attorney in Centerville, Ohio. So I'm at O'Diam and Estes Law Group. We practice really in the whole Miami Valley area, but our practice is really just focused on planning. So we do the full range of estate planning, and then we are also elder law and special needs planning attorneys. So aside from just the wills and trusts and powers of attorney that we do for typical estate plans, we dig a lot deeper into the area of long term care planning, Medicaid eligibility for long term care, and then helping families navigate how to plan ahead for their loved ones with special needs and how to, make sure that we're maintaining as much structure as we can for them, as well as preserving their eligibility for benefits and all of that. So that's why I'm here, and a little of my contact information is there on that front screen. Um, as with all things law related, I'm sorry, I'm trying to get my keyboard to cooperate with me. There we go. Um, Keep in mind that tonight I'm going to be giving a lot of general information about guardianships and some of the alternatives to guardianship. And this is not legal advice. So all of these things, as you'll learn as we talk through this more tonight, all of these things are really very specific to each family's individual circumstances, and there are lots of different elements that can impact what is best for that family, what is best for that individual. So hopefully this is good general information for you, but I do encourage you to sit down and speak with a good special needs planning attorney or estate planning attorney when you're ready to move forward with your own plan on this. Okay, so our primary goal tonight, and I guess I should say one more thing as a housekeeping matter. Um, I'm going to kind of power through these slides, but if there are questions along the way, please feel free to drop the questions in the chat box, and I'd be happy to answer. Or you're welcome to turn your camera on and raise your hand or whatever you need to do to try to get my attention. I'll also try to leave some time at the end of the presentation for some questions if you prefer to ask then. And Patty, if you would do me a favor, and if I miss a question in a chat box or somebody trying to get my attention, please help me with that, because sometimes I get into the zone and don't necessarily see what's going on around me.
I'll watch the chat box for you.
Perfect. Thank you. I appreciate
Hmm.
that. Okay, so our primary question tonight is really figuring out how do we create the best structure to allow someone to act on behalf of another individual to help with their own financial and healthcare decision making. So there's not a one size fits all in this, as we'll talk through. There's lots of options to develop something that works best for the person you're planning for, and that's going to look different for every single family. The two main options that we're going to try to cover tonight are our two most common routes within this, which is the power of attorney route, and we'll contrast that with the guardianship route. And we'll get into a little bit about how those two options work, when they're appropriate, when they're not appropriate, and what to expect as you walk through those things. So biggest goals here would be looking at the basic guardianship rules, contrast that with the structure of powers of attorney, and then hopefully dispelling some of the myths and misunderstandings that tend to kind of hover around these areas so that you can more concretely understand how this might apply to your situation and what might be best for your family. Okay, you'll hear me say this several times tonight, but the biggest kind of central theme that we have when we're deciding what we should be doing in these types of situations is first and foremost always looking out for what is in the best interest of the person that we're planning for. Okay, the best interest of that person is paramount because we're creating plans that are going to have potentially a significant impact on their life and their liberty. And in addition to just where they're living and how they're living, it's impacts their ability to do things for themselves and have autonomy over their own decision making. So we want to make sure that we're being really focused on what is actually best for them. And best looks at different levels of things. So best interest, we're going to first look at their safety. What is the best care setting? Do we have them in a setting that is just convenient but is maybe more restrictive than we need to have them in? Not looking at just what's most convenient, but looking what is best attuned to their needs to give them the highest quality of life is really important. We're also looking at their well-being. Happiness is something that I think sounds silly to focus on, but I think it's one of the most important focuses we have when we're creating these types of plans for our loved ones with special needs. Is why create a life if you're not going to build some happiness into it? So trying to have a structure that is going to promote their own happiness, peace of mind, that's all just as important as their physical health. Yes, we want their physical health and safety to be protected as well, but we also want them to have a high quality of life. And then their independence. So a lot of times, and I'm sure you guys don't do this as much because your family's living this experience alongside them, but as a society, we tend to look at somebody as a diagnosis and not as an individual. And trying to say, okay, well, because they have this diagnosis, they're not capable of doing things on their own, or they're not capable of making these kinds of decisions. And that's just not true. So as we all know very well, there's a spectrum of capabilities with every diagnosis that's out there. And so we always want to tailor whatever planning we're doing to try to preserve and promote as much independence for that individual as we possibly can. So we don't want to prematurely strip any of that away if there's a way to safely build a structure that preserves some of that independence. So we're going to start with powers of attorney. And this is always our starting point in practice too. So it's not just a starting point for the purpose of explaining things tonight. When I'm sitting down with clients in my office and talking through, what their goals are and what we're trying to look at, the first thing we're evaluating is whether or not powers of attorney might be an appropriate solution for the loved one that we're planning for. And the reason that that's where we start is because this is the least intrusive alternative. So this is the least restrictive solution that we can come up with. When it's appropriate, it can be really, really helpful. So there's two main types of powers of attorney that we talked about. And the first of those is a financial power of attorney. A lot of times you'll hear this called a durable general power of attorney. This is focused on really everything other than healthcare. Okay, so a power of attorney is just a way to name somebody to stand in my shoes and help take care of things if I'm not able to do it on my own. Okay. There's usually a very broad range of what powers we're giving to them, and I'll talk more about that in a moment. But from a foundational level, there's a few characteristics of powers of attorney that I want to kind of explain. So first of all, they're usually either durable or non-durable. And I'll tell you, in 16 years of practice, I've yet to see a non-durable power of attorney. But what this means is if I have a durable power of attorney, it means that the power of attorney continues to be effective even if I become incompetent. Okay? So even if I become incompetent, this power of attorney continues to be effective for my lifetime. So powers of attorney always terminate when the principal, the person that created the power of attorney, when the principal passes away, that power of attorney automatically terminates. But a durable power of attorney says, I'm competent today when I'm signing this, and I'm intending that this power of attorney continue to be effective even if I become incompetent. For some people, that seems a little counterintuitive because a lot of times when we think about powers of attorney, we think about them only becoming effective if I become incompetent. A lot of times people think, well, why would I have a power of attorney if I wasn't incompetent? And that's what gets us into the springing versus immediate power of attorney level. So a springing power of attorney is a power of attorney under which the authority of the agent only becomes effective if the principal becomes incompetent. So up until that point, as long as the principal is competent, the power of attorney is somewhat dormant. So it doesn't take effect until that principal becomes competent. An immediate power of attorney is a power of attorney where the moment that the principal signs the power of attorney, the authority that's given in that document is effective. So it's effective upon signing, not upon future incapacity. So breaking this down to how it works really in the real world, I would say the vast majority of powers of attorney are immediate powers of attorney. Most of them are not springing. They don't require some future finding of incapacity before they take effect. And this is important because a lot of times when you're using a power of attorney, it's not necessarily because the principal is incompetent. Sometimes they're just unavailable. Sometimes it's just a convenience. Sometimes I just want somebody to be able to help me. Not that I can't do it on my own, but maybe I have physical limitations that make it difficult for me to go out to banks and places like that and handle my day-to-day activities. So sometimes the convenience of a power of attorney is what prompts somebody to do it. I always tell the story in my own family. So I grew up the daughter of an estate planner. I'm a second generation estate planning attorney. And so in my family, this was dinner time conversation, right? We always talked about, what happens after I die and who's helping me while I'm alive. This has all been part of my life growing up. And in my family, it was, you turned 18 and it was happy birthday, blow out your candles and sign your power of attorney. That was just what we did. And I think that's important because really anybody over the age of 18 needs some sort of plan. And in my family, the way things played out, it was really pretty clear why these were important. So when my brother joined the Army when he was in college, and when he was away at basic training, his identity was stolen. Well, he had signed powers of attorney before he left, and so the bank was able to work directly with my parents, acting as my brother's agents under the power of attorney so that they were able to correct everything since he couldn't be contacted while he was at basic training. And when he was on his first deployment to Afghanistan, there was a local car dealership that was running a special on trucks for active duty service members. And my brother needed a new car, and so he went online from Afghanistan, kind of built out all the specifications for how he wanted his truck to look. He sent all of that to my dad, and my dad used the power of attorney to go to the dealership and buy the truck that my brother wanted. And that's what we drove to the airport to pick him up when he came home from his first deployment. On his second deployment, he had just gone through a divorce, and while he was deployed, he bought a house. So my parents used the power of attorney again. We gave him some video tours of houses that were for sale, and he chose one, and they purchased the house in his name under the power of attorney, which was really the best way in the world to ever move into a house, because all of his buddies came and moved all of the furniture and boxes and everything like that in. My mom and I unpacked everything, hung the pictures on the wall, and even stocked the fridge. So when he came from home from Afghanistan that second time, he literally had a ready-made home to walk into. And luckily he got out of the army after that, so he didn't have any more deployments because I wasn't sure how we were gonna one up buying a house. But those are examples that he, during those periods of time, he was perfectly competent. He was just unavailable, and it was just a matter of convenience that somebody was able to act on his behalf so that he could continue to manage his affairs even when he wasn't personally the one doing it. So that's why having that as an immediate power of attorney was really important in that context. And I would say in my career, I think I may have done maybe one or two springing powers of attorney, but probably thousands of immediate powers of attorney. General versus limited, this is an important distinction too, because the power of attorney document only gives the authority that is stated in the document. So what it says really matters. So I can't just go to the bank and say, hi, I'm Patty's power of attorney. I want to do XYZ. They have to see the document to see that the document itself, spelling out the powers, gives me the authority that I'm trying to do. So usually when we're looking at a general power of attorney, it's very broad, and it'll say I give my attorney, in fact, my agent, very broad authority to act on my behalf. But then it goes through and spells out the individual powers that are being given. And that is critical because, like I said, if the power isn't specified in the document, then the agent doesn't have the authority to do that thing. So what the document says really matters, and they're not all created equal. A limited power of attorney is one that is given for a limited specific purpose. Sometimes you'll see this in the context of, hey, I just need Patty to be my power of attorney for the purpose of selling my house on my behalf because I'm going to be out of the country when closing's happening and I just need her to be able to handle this one thing for me. So a limited power of attorney is one where we're really just narrowly tailoring it to a specific purpose and maybe even a specific duration. The other power of attorney that we deal with very frequently is a healthcare power of attorney. As the name implies, it's a power of attorney for healthcare decisions only, and it doesn't take the decision-making authority away from the principal. It's just naming somebody to make those decisions if you're not able to make them yourself. So, contrary to what we just talked about with a financial power of attorney, a healthcare power of attorney is a springing power of attorney because it only comes into effect if the principal can't make their own decisions. Okay? In Ohio, your financial power of attorney and your healthcare power of attorney must be in separate documents. So Ohio does not let those be in combined documents. So do make sure that we have clear, separate documents that delineate those powers. Oftentimes you'll see healthcare powers of attorney paired with a living will. And a living will is a little different. It's not a power of attorney. It is a directive straight from you to your doctors where you're making the decisions for yourself. So we're not naming somebody else to make decisions for you in a living will. Instead, it is a directive that generally says, if two physicians examine me and they determine there is nothing more that can be done to improve my condition, if I am permanently unconscious or I am in a terminal state, then the living will says at that point, after that determination has been made, nobody else has to decide anything. I've decided I don't want extraordinary measures, but I do want all of the comfort care. Okay, so don't keep me artificially alive on a ventilator or something like that if it's not likely to medically improve my condition, but do give me the pain meds. Give me the good stuff. Make sure that I am kept comfortable. Oftentimes it will also authorize the withdrawal of artificially supplied nutrition and hydration, but only if that stops being comfort care. So as long as that's providing comfort to somebody, generally speaking, they're going to keep it going. But for many people, at some point, it needs to be withdrawn. So a living will is really focused on helping take some of those really heavy end-of-life decisions off of your loved one's shoulders, but only when there's nothing more that can medically be tried to improve your condition. So that's why you see it oftentimes paired with a healthcare power of attorney. What it is doing is it's taking the agent's decision-making authority away if we get to that certain point. Okay, so powers of attorney, wonderful tools when they work and when they're appropriate. So let's talk about some of the limitations that we run into when it comes to powers of attorney. In just a moment, I'm going to pause for a drink. Powers of attorney. So first and foremost, these are only appropriate to use when the person creating the power of attorney has capacity to sign them. So they have to have the requisite competence in order to create these documents. Competency to create a power of attorney it's a little hard to define because it's there's not a bright line rule necessarily for competency. A diagnosis does not render somebody competent or incompetent. It's a matter of understanding in that moment and being able to appreciate what you're doing. So when I'm trying to evaluate with somebody whether or not they're competent to sign a power of attorney, I'm talking through and explaining to them what a power of attorney does, making sure that they understand that it's giving somebody the authority to act on their behalf. They're vocalizing to me who they would want to put in that role, so who they would trust to help make those decisions or give that authority to. So they have to understand what they're doing. They have to understand who they're naming, and they have to appreciate the impact that this is giving somebody the authority to do things that are going to legally bind them. It might be spending their money or obligating them to pay bills or things like that. So they have to have that level of capacity that allows them to appreciate those things, understand them enough in order to execute it. If we are in a situation where the principal of the power of attorney doesn't have the capacity, then we can't sign the document. And so then at that point, it's clear that the power of attorney isn't the appropriate route that we're going to be going down, and we have to explore other avenues. But if the person is confident, they also have to be properly executed. So in Ohio, powers of attorney need to be notarized. So we've got some formality of execution here. So some third party, some notary is there watching this happen. So, if there was a challenge to it later in court, we've got a notary that would be able to testify as to what happened and the fact that they, in that moment, felt that it was appropriate to sign. We have to have an agent who is willing to act. So just because somebody has been named as your agent doesn't obligate them to do the job. If you get to the point of when this is being used and whatever circumstances are going on in that person's life, whether it's health, whether it's relationships, whatever it is, if they just say, no, it's too much, I don't want to, or I don't really like you, so I don't want to help, whatever that is, they have to be willing to act, which is one reason when we're doing powers of attorney, I always like to have a few alternates named so that if something comes up and somebody's not able to do it, we can go down the list to the next named person and hopefully have somebody there that's able to serve in that role. The biggest challenge we see with powers of attorney right now in Ohio is that there's nothing in Ohio law that obligates a bank or some other financial institution to actually accept a power of attorney. They get to choose whether or not they want to accept your power of attorney. It's a fun little game we play. Even if the power of attorney is completely valid, the bank is allowed to reject it if they choose to. Every bank really does this very differently. There's not really a standard process that I could point to across the board. They all have slightly different rules. They all change their rules kind of frequently. So there's a bit of a roll of the dice when it comes to using these. What I'll tell you is most of the banks, what we'll see is that most of the banks' rules are tied to the age of the document. So they'll say, well, we can't honor this power of attorney because it was signed more than 5 years ago. Or, oh, this one was signed more than 3 years ago. Or recently we had a bank that rejected a power of attorney because it had been signed more than 6 months ago, and it was 6 months and 1 day old. So even with that recent of a power of attorney, there's not necessarily a guarantee. So I'm hopeful that at some point we can get some improvements to Ohio law to give some sort of enforceability, reliability with these documents. But as it stands right now, we are still somewhat at the mercy of the bank. And, we try to beef ours up as much as possible to make it as likely as possible that these will be honored when when we need them to be. But there is still that question of, will the bank allow us to use this when we need to? Another potential challenge, and sometimes this is a positive, but sometimes it's a negative, is that there's no third party oversight with the power of attorney. So from an administrative perspective, that can be nice because we're not having to account to a court or ask permission to a court or something like that in order to do things. But that can be a drawback too because sometimes having third party oversight is a good protection for that principal. What if what if the agent under the power of attorney goes rogue and starts doing their own thing, maybe beyond the scope of the powers of the power of attorney, or something that's not really in the principal's best interest but is more self-serving to them. There's not formal third-party oversight when it comes to the day-to-day operations of a power of attorney. Again, we try to beef ours up a little bit with this to make sure that there is some accountability built in. We say, hey, the agent has to be able to, provide reports to the other named successor agents or to my children or to my spouse or whatever that might look like, just to give some checks and balances there. But generally speaking, it's not something that's required unless it's built into the document. And then there's often no method in a power of attorney for determining competency. The reason that this matters and the reason that this has a kind of a bigger impact on using a power of attorney is that a power of attorney is a voluntary arrangement. Okay? If I am signing a power of attorney to name Patty as my agent, I am doing that of my own free will, and I have the right to change my mind later. Okay? So if I change my mind, my relationship or trust with Patty deteriorates, I can go back and revoke my power of attorney or name somebody else as my agent or do whatever I need to do. So, in theory, what that means, that's a good thing because I can make it change with my goals and circumstances as they might change. But where it gets a little bit challenging is in a situation where the agent wants to do something that is contrary to the wishes of the principal. So if they want to act against my will, then we might have an issue. So let's say I've I've named Patty as my power of attorney, and years have gone by. She's acted successfully as my power of attorney for years. But now we've gotten to a point, maybe I have a dementia related illness or something is happening and my capacity has waned. And I'm maybe now even at a point where I don't have capacity. I no longer have capacity. But it's a durable power of attorney, so Patty's authority continues even if I lose my mental capacity. Well, if maybe my safety at home is now becoming questionable. We oftentimes see this with our dementia clients where there can be issues of wandering or issues of unsafe practices in the home, like they turn the stove on and forget about it and then put a towel on the stove that could catch fire. There's things that can happen that make it really unsafe for them to stay at home. And maybe it gets to the point that Patty's determined, well, Brittany's no longer safe at home. I really need to move her into an assisted living facility or something like that where there is a little bit more protection and help and structure around that. But I don't want to go. So if Patty finds the nice facility that's willing to, has a spot for me to move in as a resident, and the day comes that I'm to be moved in, but I don't want to go, the facility sometimes, and this isn't true of every facility and every such situation, but what we found is that if there's some question as to whether I am or am not competent, the facility oftentimes will not accept me as a resident against my wishes. I have to go willingly. And if I'm not going willingly, then they won't allow Patty to make that decision on my behalf as my agent under my power of attorney. Patty's only option at that point, in order to get me to a safer setting, to enforce her wishes over my wishes, would be to pursue guardianship and have a formal declaration of capacity. And the reason that makes a difference is that the only way to have a legal determination of incompetency in Ohio is for a probate court to issue an
Trying to
order.
get him out of the bathroom.
So what that means is that If my doctor says I'm no longer competent, that is very compelling evidence, but it doesn't necessarily make me legally incompetent. So the only way to have that formal determination is for a judge to say so. So just my agent under my power of attorney saying, look at all of these diagnoses. I have doctor's notes saying that she's no longer competent. It's very clear. It's not legally binding until a judge says it is. So powers of attorney can be an excellent tool when they work, but we do have these limitations that sometimes we butt up against. And when we butt up against these limitations, sometimes we have to turn to a different solution and explore what needs to go on from there. I have worked with a lot of families, with kiddos with developmental disabilities who are reaching that 18 and beyond age range and trying to figure out the best structure for what should we do? How do we make it so that mom and dad are still able to help? But, do we do a guardianship? Do we do powers of attorney? And where we have a situation where maybe the kiddo is pretty borderline on their capacity, we might start with a power of attorney. If they can understand and appreciate and be part of the conversation and decide, yeah, this is what I want to do, and I'm comfortable that they fully understand it. Oftentimes we will start with a power of attorney. So, kiddo names mom or dad or grandma or whoever to serve as their agent, and then they figure out a way to kind of work together on that and start a new routine within that. Sometimes it works beautifully and we carry on that way for a very long time indefinitely. Sometimes it works for a period of time, but can help us better understand that kid's capabilities in a more concrete way. So, for instance, if we have a situation where maybe daughter names mom as her agent under power of attorney, mom and daughter work together to make sure that bills are paid and develop budgets and mom helps her understand more about the rhythms of financial maturity and things like that. And all of it can be working really well, but then maybe they have a mental health episode or some sort of triggering instance in their life that sends things off tracks a little bit. Maybe police are involved, or maybe there's behavioral issues, or just some sort of rebelling. Well, one challenge in that situation then is where we have the child as the principal in this. Remember, powers of attorney are voluntary. And so if that child decides, I'm mad at mom and I don't want her to help me with this anymore, she has the right to revoke that power of attorney and decide that they don't want a power of attorney or that they want somebody else to be named as their agent. And it can lead to a little bit of an issue there. So in situations like that, sometimes we have to get back, revisit the situation, determine what is the next best stop, and do we need to pursue guardianship at that point. So it can be a nice stopgap to even try first because, again, we like to start with the least intrusive method. But where powers of attorney are not effective enough or we need to move to something different, that's when we start to look towards guardianships. So we do try to use this as our last resort. When there's no other plan available, there's not something that is less intrusive that we can look to first. So this is when we have an adult who's not competent to sign a power of attorney. We have the need to do something that is involuntary. So that involuntary institutionalization, kind of that example I talked about, if Patty needed to move me to assisted living because I'm not safely able to remain at home, but doing so is against my will, we need to maybe have a guardianship pursuit in that case. Sometimes it's the need to override the principal's bad decision making, enforcing the better choice. This is a really tricky area because, and I have this conversation with families all the time, and I haven't come up with the best solution because I don't know that there is one, but so often I have families come to me and say, hey, they're competent, they named me as their power of attorney, I'm helping, but they're still controlling some of their finances, they're still paying bills and stuff alongside of me, but they're doing some really wacky things. They're giving money to everybody that asks for it. They're writing checks to their friends and paying for everything on behalf of their friends. And I'm afraid that this is getting to a level that shows that they're no longer competent. And it is a tricky thing because bad decision making can be evidence of incompetence. Sometimes that's something that shows us that this person maybe doesn't have capacity to continue making decisions on their own. But people are still allowed to make bad decisions if they choose to, right? So sometimes it's a matter of we can't substitute our decision making for their decision making. If they want to make that bad decision, they're allowed to if they're competent. And we all know competence is kind of a gray area that you can be competent for some things and not for all things. And so sometimes it's that sliding scale. And if somebody is still arguably competent or we don't have that formal determination of incompetence, then they are entitled to make the decisions that you don't agree with. So, but sometimes a pattern of those bad decisions can be a sign for us to know that, oh gosh, I think we need to have a different structure and something more concrete in place. Other issues that we look for to look towards guardianship is not necessarily what's happening just with the individual, but what's happening with respect to people around the individual. So is this person really susceptible to undue influence? Are they doing things just because the person next to them is telling them to? They're not really making that decision themselves. They're only doing it because somebody's asserting some pressure on them and they want to make that person happy. Sometimes it rises to the level of actual abuse or exploitation. Somebody's taking advantage of them. They're taking their money, getting them to spend money on things that they don't understand. Sometimes it's threats of, oh, you better do this or I'm going to go put you in a nursing home, or you've got to only talk to me because everybody else wants to hurt you and I'm the only one that's trying to help you. So we look at those kind of outside relationships too to make sure that we understand how this decision making is coming about, and is it really the person that's making the decision, or is it the influence and the extraneous things that are impacting this. So sometimes that's our trigger, our sign that we need to go through the guardianship process. So when we've determined that it's a situation where guardianship seems to be the more appropriate choice, there's some options here. So I'm going to go through a little bit of vocab, a little bit of just the education side of things before we talk about the guardianship process. But there's really two main options when we talk about the court process for overseeing decision making. It's guardianship and conservatorship. Conservatorships are very uncommonly used. This is not something that is typically seen because a conservatorship is essentially a voluntary guardianship. So in a conservatorship, the ward is not incompetent. They are still competent, but they're asking the court to name somebody to serve as their conservator. So they're voluntarily entering into this arrangement and then having the court oversee just as we would in a guardianship. Usually we see this in the context of situations where somebody is maybe extremely physically disabled but still mentally competent, and they want to have somebody that's able to help them, but they want to have court oversight and that structure and accountability built in. So that's oftentimes where we see conservatorships, but again, those are very rare. So guardianship is going to be our focus going forward from here. And that is the process of managing the person and or the estate of somebody who is a minor or who is mentally incompetent and over the age of 18 with ongoing probate court supervision. So there's a whole process that we're going to talk about. You apply to the court to be appointed guardian. You're not just automatically the guardian because of a relationship you have with the person. And we have to prove the mental incompetence piece and prove that you're the best person for the job. And we're going to talk about how we do that. So a little vocab lesson here. When I say the ward is the person for whom the guardianship is being sought. So this is the subject of the guardianship, the person that needs the help. The applicant is the person applying to be the guardian. So they are the applicant until the court names them as the guardian. So being a guardian is a court-appointed role. It's not something that just because I have somebody nominated to be the guardian of my kids if I die. So my will says, hey, if I die, my kids are still minors, here's who I want to be their guardian. That is just a nomination until a court actually names them as the guardian. Okay, so just a little bit of a distinction there. The guardianship process, the entire process, is centered around basically four main points. The first point that we look at in the guardianship process in determining whether this is the right route to go, and this is exactly when I'm in a hearing in front of a court, these are the 4 points that I'm trying to prove to the court in my hearing. So this is the framework I use for my first meeting to discuss guardianship with the family, but this is also the framework I use when I'm in front of the court and trying to present everything to the judge. So first and foremost is the ward incompetent? We have to prove that the ward lacks the mental capacity to make decisions on their own behalf. And the way that we do this is through a variety of evidence. So we have applications and forms that we file that contain information that the applicant is providing to the court. We also provide medical evidence completed by the treating physician, somebody that has examined the ward and can give their expert medical opinion as to the ward's incompetency. And then the court also has their own investigation process, because when we file a guardianship application, the court sends its own court investigator out to meet the ward and kind of get their own eyes on the situation. So the first thing that a judge is determining in a guardianship process is whether or not that ward is in fact incompetent. And I'm going to talk more about what that looks like in the hearing side in a moment. But that's our first question, because if the answer to this is no, the ward is competent, is the ward incompetent? No, they are competent. Then we stop there. If the ward is competent, then we don't have a guardianship case. That is not the appropriate route to go. We cannot pursue a guardianship for a ward that is still competent. That's when we have to look at conservatorship or powers of attorney or some other alternative. But if the answer is yes, the ward is incompetent, then we look to the next question here. Are there any less intrusive alternatives to guardianship? So powers of attorney, like we talked about, the reason that we start there is it is a less intrusive alternative to guardianship. If we can safely do things through a power of attorney, we want to start there and maybe stay there. If the power of attorney is still working, there's not a need to go through the guardianship process, even if somebody loses capacity. So sometimes in that situation the example I gave earlier where Patty needs to move me to assisted living, but it's against my will. If Patty is filing for guardianship over me, what we're doing is we're trying to say, hey, court, Brittany is incompetent. There is a less intrusive alternative. I have this power of attorney here that she filled out when she was competent, and we really only need this guardianship in order to enforce this less intrusive alternative. But one of the tenets of guardianship is when we are filing the application, we have to disclose to the court whether any powers of attorney exist. Because if they exist, the court's going to say, why aren't you using that? And if you can show why the power of attorney isn't working, then we'll move forward in the guardianship process. But if the power of attorney is working, then a guardianship isn't needed and the court's going to deny it. So that's our second question. The third is the applicant the best person to serve as the guardian? So just because you apply doesn't mean you're always the best person for the job. So the court wants to look at the applicant themselves. So we're not just focusing on the ward, we're focusing on the applicant too, because we want to make sure that there's not somebody that is better suited to do this. And so within that, we're looking at background checks, we're looking at criminal history, we're looking at the relationship between the applicant and the ward. Do they get along? Do you regularly see each other? Is it an acrimonious relationship, or is this something that's going to be a harmonious thing going forward? So the court's really going to dig into that, and that's important, especially when we might have competing applications. Maybe we have multiple people applying to be this person's guardian, and the court is in the position of deciding who gets the job. So finding who the best person is going to be really important. And then ultimately, it goes back to that cornerstone consideration that I mentioned at the beginning. What is in the best interest of the ward? Okay, so even if they are incompetent, there's not a less intrusive alternative. This person might be a good person to go for to be the guardian, but is this still in the best interest of the ward? Sometimes there's another alternative that we have to explore that might be better for the ward. So maybe they do have a good relationship with this applicant, but somehow it would be better if we had a third party serving in this role. So the court's going to infuse that fourth point really into each of the preceding three. So to make sure that each of these ultimately funnels down to that best interest of the ward, and that's what we're protecting above all else. So the first, excuse me, my eye itches here. The first bullet point that I had on that last screen was related to competency. So the formal definition of incompetent, and this is under Ohio law, is any person who is so mentally impaired as a result of a mental or physical illness or disability or mental retardation as a result of chronic substance abuse that the person is incapable of taking proper care of the person's self or property, or to provide for the person's family or other people for whom the person is charged by law to provide, or somebody who is confined to a correctional institution within the state. That is the legal definition. I don't love it. I'm going to be real honest with you. I think that sometimes it gets confused. It gets kind of conflated as to what it's supposed to mean. The biggest issue I take with this, and I've had this come up in a couple cases, is the mention of physical disability. So incompetency has nothing to do with somebody's physical capabilities, right? We've all seen situations where somebody might have a physical disability that manifests itself so pervasively that it appears that that person might have mental impairment when they don't. So I've had, I had a client who had a series of strokes and some other physical illnesses that rendered her almost nonverbal. She was still able to communicate, but communication was very, very difficult for her. She was having difficulty getting around. Her appearance had changed dramatically. She appeared disabled. When you spoke with her, it was very hard to have a conversation unless you were really taking your time and having, a lot of patience with it. And in the case that we were handling, her daughter was filing guardianship against her, and the mom hired me to prove that she was competent. And the biggest obstacle we had to overcome was getting everybody beyond her physical disability to look at her mental capability. So I don't love the mention of physical disability in here because I think it can confuse things, and that's the point I had to argue with the court in that case. But this is the legal definition of incompetence. To that point that I was just making about defending my client that was competent, it's really important to keep in mind that this is not just a one-way street. This is a two-way street when it comes to competency. So just because somebody files guardianship doesn't mean that we're automatically going down that path, because the ward, or the prospective ward in that case, has the right to prove that they are competent. And technically, they don't really have to prove it because the burden is on the applicant to prove that the ward is incompetent. So I can present, if I'm the one, if Patty's filing that guardianship, sorry Patty to pick on you this whole time, but Patty's filing that guardianship against me and I don't think it's justified, I don't think it has foundation. Patty has the burden to prove that I'm incompetent. I can sit back and do nothing and just let her try to prove that. But I also am entitled to present evidence of my competence to controvert whatever evidence that Patty might present. That comes in the form of I have the right to testify at my own hearing. I have the right to an attorney. I have the right to the court paying for an attorney if I can't afford one. I have the right to present witnesses. I have the right to present my own medical evaluations or medical evidence. I have the right to show the court that this isn't the right direction it needs to go. And that's really important because, again, going back to what we've talked about a few times here, is guardianship ultimately can have a huge impact on the prospective ward's independence and liberty. And so we don't want to take that lightly. They have the right to have a say in this and make sure that nothing is being done flippantly, nothing is being done without due process, and making sure that this is the best thing for them. So that best interest piece and that cautious liberty piece is really, really important. So they do have the right to participate and they have the right to challenge it. So let's say we're in a situation though where it's pretty clear, okay, guardianship is appropriate. All of those four pieces are met and we are going to go down that path. So, where do we start? First and foremost, we have to decide what type of guardianship we're going to be using. And this is not a one size fits all. So, this is something that is, again, fine tuned to the individual circumstances of that family, of that case. So, an unlimited guardianship is kind of the blanket guardianship for all things and all purposes. So, we call it a plenary guardianship. Um, these are common, but sometimes I think they're overused. My preference is always to see where we can limit things, again, to avoid infringing on liberties that this person should be able to maintain for themselves. So I like to fine tailor our guardianship as much as we possibly can, and that's where I like to look at limited guardianships. Digging in with the family to figure out what this person's capabilities are and where their weaknesses are, so that we can build a guardianship that is structured around their weaknesses but not infringing on their strengths. So, like if it's a guardianship, I might be talking to them about, well, okay, they need help with the medical decisions, they need help with these kinds of things, but can they vote? Do they understand the political process? Do they want to be a part of that? Should we preserve their ability to vote? What about driving? What about working? What about, some of these things? We want to try to make sure that we're really getting to know the person and their best interests, so that we can build this to best reflect what they need. Um, do we look at a guardianship of the person or of the estate, or maybe both? So, a guardianship of the person is naming somebody as guardian that has authority to make care and custody decisions on behalf of the ward. So, kind of where they're living, participating in IEPs or any kind of those educational decisions, being able to make medical decisions on behalf of that person, and just those kind of more personal related decisions that don't have anything to do with money or property. A guardianship of the estate is when we have somebody that needs help managing money or things that they own. So, as you can imagine, with the many, many families we help where we're getting guardianships in the context of a kiddo with developmental disabilities who's turning 18, most of those kids don't have an estate yet. Most of them don't own a whole lot. They're not sitting on, a couple pieces of real estate in a 401k or anything like that. Um, in the circumstances where they do have a bank account, maybe grandma's been making gifts or whatever the case might be, usually there's things that we can do to plan for that using maybe stable accounts or other alternatives, so that we don't necessarily have to have a guardianship of the estate. But if the ward does have assets, does have income, does have money outside of Social Security, then we do need to do a guardianship of the estate, so that somebody has the authority to manage that on behalf of the ward. A lot of times, it might be both. Sometimes we might have one person as guardian of the person and one person as guardian of the estate, because people have different strengths. So again, we try to build this out however works best for that individual. And then we have emergency guardianship. So emergency guardianships are, as the name implies, emergent situations where there's an imminent threat to that person's safety from a financial or a health standpoint, and that we have to get this guardianship in place right away without delay, so that we can prevent this emergency from happening. These are very sparingly given. We have to have an actual emergency, not just, oh no, I waited too long and now I need to do it. But the court has to see that there's an actual imminent threat of harm. And if that presents itself, then we can file this emergency guardianship. If it's accepted, the court will make that person the guardian for 72 hours. And that within that 72 hours, the court is going to hold an emergency guardianship hearing, at which you have to present additional evidence of what's going on and why this emergency exists. And the court can then extend that emergency guardianship for up to 30 days. But within that 30 days, we have to then have a full guardianship hearing in order to extend that beyond it. So it is there as a safety net, but it is not something that is used except for in true emergencies. So where do we begin? Sorry. So we've decided what type of guardianship is needed. We have a whole slew of forms that the court has us complete, and this is kind of county specific. So county by county throughout Ohio, there's 88 different ways to do guardianships in Ohio. But generally speaking, there's an application. Usually the application is just giving general information about why we're here, why we're filing this, who the ward is, and all of that. Usually there's supplemental information sheets that we need to file, giving more information on the applicant and more information on the ward so the court has a more well-rounded insight into what's going on. The statement of expert evaluation. So this is the form that we have filled out, completed by a physician, and the physician has it has to be somebody who has physically or in person treated the prospective ward within 90 days before filing the application. So oftentimes, as we all know how doctor scheduling can be, sometimes this is the biggest obstacle we have to filing because we have to get an appointment. So if you're the parent of a kid who's going to be 18 in the coming months, get that doctor's appointment on the books if this is something that you're going to need to do, so that we can have a doctor that has examined the ward within the requisite time period. Because after that 90 days, we can't file the statement of expert evaluation if they examined them 4 months ago. It has to be 3 months ago. It has to be completed by a physician. I know that's another annoying point because a lot of people see nurse practitioners and PAs and things like that, but this does require a physician. And on the statement of expert evaluation, at the end of it, there is a place where the physician gives their opinion. Does a guardianship need to be instituted and or continued or whatever it is? And so we always want to make sure that they actually filled that out as yes, because if you submit one that says no, it's not going to help you. So doctors are usually really great about completing these, and so we usually give them to our clients at the outset so that they can pass them along to the doctors, and then we're there to help explain. But most doctors who are treating people in these scenarios are really good about filling these out. If we're doing a guardianship of the estate, then the guardian must post bond, and the bond has to be double the value of the assets in the estate, except for real estate. So if I have a ward who has $25,000, the applicant needs to post a bond in the amount of $50,000. These bonds are done through insurance agencies, so we just work with an insurance agency to get that bond so that we can show the court. And the idea there is that it's just security to make sure that this guardian isn't going to run away with the money and the ward's going to be left holding the bag. Every guardian needs to go through a background check, so different counties have different levels that they want to do on that, so we have to submit that background check with the application. We have to notify all next of kin, so next of kin of the ward. So let's say mom is the one applying to be guardian of the ward. We need to make sure we have dad signing off on that as well. If mom and dad aren't in the picture, then we're looking at grandparents and siblings and people like that. But we have to notify all of the closest living relatives. And the idea there is that the court wants to make sure that they are aware of what's happening, that these are conceivably the people that would be best in tune to the best interest of the ward. And so we want them in the loop on what's happening so that if there's any problems that the court should know about, they're alerted and can come to court and make sure that that issue is known. And then whatever else the court might require, drop of blood, lock of hair, whatever that might look like, we'll give them whatever they need to process that. But they usually have a pretty good checklist within that. So we file that application, packet all of the information. Some courts, the traditional rule is that you can't file it until the 18th birthday. So we get all of this work gathered ahead of time. Usually I recommend clients start the process 4 or 5 months before that 18th birthday. So you've got enough time to get all of these pieces gathered. But we get all of that. We can't file it until the 18th birthday. However, I will tell you that over the last year or so, we've been working with some of the local courts on pushing back on this and saying, why can't we file it before the application or before the 18th birthday, as long as the hearing is still after the 18th birthday? Because the hearing is what matters, not the application date. And so there have been, most of our local courts are now giving us some grace period there where we can file it in some cases up to 30 days before the 18th birthday. And that's helpful because when you file the application packet, what happens is that the court will then set it for hearing. Depending on what county you're in, that hearing is going to be sometime after the application has been filed. So it's going to be at least 2 weeks. By Ohio law, it has to be at least 2 weeks later. Some cases, it might be 6 or 8 weeks later because of the court just being too busy. So filing it earlier and not having that gap of time between filing the application and the 18th birthday can be nice to make sure that there's not any concern. So we're working on kind of improving the process on that. But once we've got that all filed, like I said, they're going to set it for hearing. The hearing is in person at the court. They do a really good job of trying to keep it very informal. So very comfortable, unless it's a contested guardianship, in which case then we're going to have more of a formal process that you'd expect for a court proceeding. But generally speaking, especially where it's like, mom or dad or grandma or somebody just applying to be the guardian of a kiddo with developmental disabilities, they're going to make it pretty relaxed, pretty laid back. It's a conversation. The judge or the magistrate, depending on the county, is running things, and they always talk to the applicant first. Make sure that they know who you are and that they're getting, they might have a couple questions about things that were contained in your application, just to make sure that they've got the full picture. Ask if anybody is going to be testifying as witnesses, and then they'll turn their attention to the ward. So if the ward chooses to come, which they're allowed to come, I mentioned that earlier. They don't have to come though, so if it's not something that they want to do, they don't have to. And even if they're there, they don't necessarily have to speak. So if they'd prefer not to, they don't have to. But they do have the right to speak, and sometimes this can be a really fun thing for some of my clients. That's kind of a field trip to the courthouse, an opportunity to see a new place and experience something. And like I said, most of the judges and magistrates around here are really good about making it kind of a neat experience for them too. One thing I mentioned earlier, but I didn't necessarily go into detail on. So when we file that application, I mentioned that there has to be at least 2 weeks. That's so that during that 2-week period, the court can send its court investigator out. So that court investigator, as we talked about earlier, is somebody from the court that's going out and physically meeting with the ward so that they can get their own eyes on the situation and see what's going on. So the judge is, prior to this hearing, is going through the entire application packet, the information we've submitted, the information the physician has submitted, and the information that the court investigator has submitted. And that's what they're basing all of their questions off of. Typically, where we have a case where it's a guardianship of an adult with developmental disabilities, most of the time, the final decision is going to be made at that hearing. So if it's a judge, a lot of times they'll just issue the letters of guardianship right away. If it's a magistrate, they'll say, we're going to recommend to the judge that they issue letters of guardianship, and that'll be done within just a couple days. So usually, though, at the end of that hearing, we have our final decision. But there are situations where maybe some additional medical information needs to be given. Maybe we need to have an additional evaluation to make something more clear, or more time for witnesses to be gathered, or whatever might need to happen. So there could be a continuation of that and an additional hearing, but that's the exception and not the rule. After the guardianship is put in place, then there are a few things that need to be maintained going forward. So first of all, Ohio law has mandatory guardian education. There's a 6-hour initial course, and then every year that the guardianship continues, there are 3-hour ongoing courses. Most counties will let you defer the education requirement if you are the parent of the ward and the ward is an adult with developmental disabilities. And the idea here is, what education can we give you to continue doing what you've been doing already for 18 years? There are some courts, like for Montgomery County, for instance, requires that the parent parent guardian take the 6-hour initial course and the first 3-hour course. And after 1 year, then they can file a deferral so that they don't have to do those ongoing 3-hour courses. Some counties, like Greene County, typically will make it so that they will defer the education from the outset and not make you take any of them. And all of these are deferrals, they're not waivers. So what that means is they're deferred as long as you're remaining compliant with the other requirements of the guardianship. But if you start to slip on deadlines or things like that, then they're going to step in and say, no, now you need to go take that guardian education. So what are those ongoing requirements? So first of all, if we're dealing with a guardianship of the person, which is our most common that we use in this context, there's a guardianship plan. So this is the prospective plan for what the guardian is intending to do for or with the ward over the coming year or 2 years. There's a guardianship report, which is a report on what happened related to the plan. So over the last 2 years, here's what my plan said, and here's a report of how things went. So we have these kind of the cycle through that we have a report or we have a plan and then we report on it, and then we have a plan and then we report on it. Different counties have different time zones or timelines for these. Some of them require them annually, some require them every 2 years. If we have a guardianship of the estate, then we have within 90 days of the start of the guardianship, we have to file a full inventory of everything that the ward owns. And then every year we have to file an accounting to show every penny that went in and every penny that went out of the guardianship, or I'm sorry, of the estate. With a guardianship of the estate, another really important piece to keep in mind is that the guardian is not permitted to spend any of the ward's money without prior court approval. So, what happens in a guardianship is that while mom might be named guardian, what is really legally happening is that the court has become the superior guardian of the ward. Mom, as guardian, is really just the liaison between the ward and the court. So their job is to be the go-between, to make sure that the court is aware of what the ward needs and to report to the court as to how things are going. So mom, individually as guardian, doesn't have the authority to make decisions without the superior guardian, the court's approval. So when a guardianship of an estate, that can get kind of cumbersome because we have to seek those ongoing approvals. In a guardianship of the person, the same is true, but it's not that you have to ask the court permission to take the ward to the doctor or something like that. Really, the only time we have to ask the court permission in a guardianship of the person is if the ward is going to be moved to a more restrictive setting. So, like if they're living at home or they're living in an apartment, and circumstances change and they need to be moved into maybe a group home or some sort of institutional setting, then the court needs to pre-approve that. They have to approve that before that move happens. So all of this is just related to making sure that the court stays apprised of what's happening with the ward and that nothing's being done without the court's prior knowledge and consent. Okay, so that's the guardianship process. And I know I'm going a little over on time, so Patty, stop me whenever you want to. I'd say throw something at me, but we're not close enough. But as parents, I know many of you are parents or caregivers for individuals with disabilities, and I want to make sure that I encourage you not just to look at what's best for them, but also what's best for you. Make sure that your plan is in place, that you've got appropriate powers of attorney and healthcare directives and your wills and trusts and maybe appropriate life insurance or things like that, so that if something happens to you, your plan can move forward smoothly, because that's going to bear a direct impact on what happens with your loved one, and how smooth any kind of transition and care goes for them as well. So definitely, I know as caregivers, it's a hard thing to get you to focus on yourself, but that is a very important thing to do, not just on your own health and mental health, but also on your legal health and making sure that your own plan is in place. So if you're alive but you become incompetent, or if you pass away, who takes care of you and who takes care of your special needs loved ones? So that is a very important question. And with that, I will stop talking. If anybody has any questions, I am more than happy to answer them. I'll stick around as long as you need me to. But I'm going to stop sharing so I can see faces a little bit easier.
Let me go ahead and stop the recording, Brittany. So if
Okay,
anybody wants to ask without being
sure.
recorded, we're all set. But thank you. Thank you again
Okay.
for your presentation on this. It
Yeah.
is such a tricky topic. So, but one second, let me